Hey, welcome to today's video. I'm Rick Chapo with DMCA So today we're looking at a fairly straightforward question. Who owns intellectual property? And the answer is it's generally straightforward, except for, one particular situation. So let's hop into it. What is intellectual property? So there are different classifications. The three that are most commonly well known are copyright, trademark, and patent law, or patent rights. Now, copyright applies to a creative work of some substance that is fixed. So if you think about J.K. Rowling writes a new book, a new Harry Potter book, that would be a copyrighted work. With a trademark, we're talking about a symbol or short phrase that is an identifier of a product or service and is used in commerce. And basically a situation where the consumers would see that short phrase or that symbol and associate it with a particular product, service, or company. So if you think of the Nike swoosh, for instance, when you see that swoosh, you think Nike. And maybe you think of that positively or negatively. It doesn't really matter. You associate it with Nike. And if you buy a product with that swoosh on it, you're expecting a Nike product, and that's what you're going to get. With a patent, we're talking about inventions. And so when somebody invents something, we give them the patent rights to it because we want them to benefit from it, because often inventing things takes a lot of time and sometimes a lot of money. So if we're talking about drugs, for instance, if you want to develop a new medication and go ahead and put it on the market, you have to go through the development process, and you have to go through testing and getting it approved, and that can be very expensive. And so we're going to give companies a certain period of time to benefit from that. And so who owns each of these forms of intellectual property? And the answer is the creator. It's the person who creates the specific work. So if we're talking about copyright, when J.K. Rowling writes that book, she owns the copyright to it. And what that basically means is she's the only person who can use it in whatever way she sees fit to benefit from it. With the trademark, same thing. Whoever creates the mark or the phrase typically is going to own it. In that situation, it's usually going to be a company in one form or another, because trademarks, it's not like a book where you just randomly sit around at home thinking, I want to be the next great trademarkist. It's just not going to be the case. With patents, again, person who creates it, we're going to give them the sole right to use it in whatever way they see fit and to benefit from it. Now, and why do we do this? Why do we give people these rights? Because we want to encourage people to go out and create things. We want to encourage people to go out and create copyrighted works, to write books, to shoot movies, to create music, to do these types of things. And when they do that, they should be able to benefit from it. Again, with inventions, we want to promote inventions. We want people to go out and create inventions. If you're watching this on your PC or your smartphone, well, you might not be if we didn't have patent law, because would people have spent the time and money necessary to go ahead and develop all these things if they couldn't protect them? Maybe, but let's just say society would be a little more primitive than it is now, because a lot of the things we have wouldn't exist, because it was just too much effort and time and money to put them in place. And then with trademarks are a little different. Isn't so much that we want to promote creativity as we want to create a method that consumers can use to know, or at least associate, confidence, if you will, have confidence in products or services. So, when they see a particular slogan or short phrase, they associate with the company, and they know, they have confidence that they're going to get whatever that product is, at a certain level of quality or what have you. If you see the Apple silhouette, with the bite mark out of it, it's an Apple product, an iPhone, an iPad, whatever it is. And so you associate a certain functionality and quality with that product. And that's, so you're either going to make the purchase or you're not, depending on that. And that we want to promote. So, generally speaking, he who creates it owns it. However, that simple answer gets a little more complex when we look at real world situations. And the most common problem that comes up is one where a employee in a company creates the intellectual property work. So let's go back to the Nike swoosh. Now, I don't know what actually happened with the swoosh, but commonly what would happen when somebody's trying to come up with that swoosh is not somebody independently sitting in bed one night, trying to think up trademark symbol. Instead, it's often probably the marketing or the product development department at Nike who came up with that, or maybe an independent marketing company they had hired. Now, a company, in that sense, doesn't really come up with it. There's somebody somewhere in that department who thought, "Hey, what about a swoosh?" Um, and they came up with the idea, and it probably went through revisions and everything else. Well, does that person who came up with that idea own it? And the answer under intellectual property law is no. No, they don't. Because if you are an employee and you create a form of intellectual property within the scope of your work, then the company is going to own it. That's a general rule, and it makes sense if you think about it. Because let's apply it to a different situation. If you think about Microsoft, okay, well, they create Windows 10. Whatever you may think of Windows 10, they use probably thousands of programmers to come up with that program. They're paying all these programmers a salary, and let's get this done. And it's an incredibly complex project. Now, if we allowed each of those employees, to own their own little chunk of Windows 10, it would be complete chaos. Microsoft's paying them money to develop the product, and so we're going to give Microsoft that benefit and have the intellectual property rights associated with Windows 10 and the programming that each of these individuals creates, going to Microsoft, and that kind of makes sense. You can see how that would work. Now, where things get a little less clear is where the intellectual property that's created is potentially not within the scope of work. And there's been just a wee bit of litigation over this issue. So let's think of a position. Let's say that you work for an IT company. And so this company gets hired by other companies to go out and fix and maintain their IT systems. Everybody has an IT system these days, it seems. And so as an employee, you go out and you work on these things. And so let's say maybe you're responsible for 20 different companies, and you bounce between these companies. And you keep seeing the same problem all the time. And you're thinking, man, I wish there was a software product out there. Somebody had created one that could fix this problem, because it would make life so much easier. And then a little light bulb goes off in your head and you think, hey, that's an idea for a business. And so after work, you go home and you start writing, software. You learn how to program, you learn the Python program, and next thing you know, you're writing software. And eventually you get to a point where you have the software perfected and it will work. And you decide, okay, I'm quitting my job. I'm going to start my own company and start selling this property or this software. Well, the question is, who owns that software? Is it your former employer? Because obviously you created the software while you were in that job. But is software, writing software within your scope of work when you were an employee? And I don't think many IT employees are actually writing software. I don't really know, to be honest, but I would think that they're probably not. So that would tend to suggest that it's not. But then again, you came up with the idea while you were in the job, and the software solves an IT problem. So that might weigh against you. And as you can guess at this point, really what you're going to want to do is take it to a lawyer, because you have to sit down and show the lawyer, here's what I did, here's what I was doing as an employee, and they're going to compare it to case law and give you an opinion as to how this is all going to play out. Now, there's an additional caveat to this, which is companies have become smart in this area. And if they hire people in any kind of position that might involve the creation of intellectual property, they will often have you sign an employment agreement or some kind of agreement when you first become an employee that covers intellectual property. So you need to go dig that out if you sign something, and show that to the lawyer as well, because it probably has language in there that addresses who owns the intellectual property that you create while you're an employee. So that's very important. So there we are. Who owns intellectual property? Generally, it's a person who creates it, unless they are an employee. And if you are an employee, then it boils down to questions of what was your scope of employment, what kind of agreements did you sign, and the kind of things that you really need to sit down and have a lawyer look at. So anyways, that's it for today's video. If you have any questions or comments, post them below. I'll be happy to answer them. Otherwise, thanks for watching.